Imagine this for a second. You walk out to your mailbox.
Okay.
You've been fighting this massive, deeply stressful battle over your home, right? And you finally filed a serious, formal complaint with a government watchdog.
Which is already a huge undertaking.
Exactly. So you open the envelope, pull out the official letterhead, and start reading. And the letter officially dismisses your complaint entirely.
Oof. That is a gut punch.
Total gut punch, right. But then you look closer at the details. You look at the dates, and you realize the government agency is claiming they received your complaint on a date that hasn't even happened yet.
Wait, what?
Yeah. You're holding a rejection letter riddled with dates from the future.
I mean, it sounds like a glitch in the Matrix. But when it happens in the real world, especially when your housing is on the line, it is incredibly disorienting.
It is the absolute definition of a bureaucratic twilight zone. And, well, that is exactly what we are getting into today on this deep dive.
Yeah, we really are.
We've got a fascinating stack of documents sitting on the table. Our main sources include a formal complaint decline letter from the Office of the Information and Privacy Commissioner for British Columbia.
We'll just call them the OIPC to keep it simple.
Right, the OIPC. We also have an urgent reconsideration request from a citizen named Johnny Zakharia, along with a set of exhibit posters concerning administrative complaints and organizational threats.
It's a very revealing paper trail, because it takes something that usually feels totally abstract like data privacy law, specifically the Personal Information Protection Act, or PIPA,
right,
and it shows what happens when that dry law becomes a very real, very high-stakes battleground.
Okay, let's unpack this, because our mission today is to look at this specific David versus Goliath scenario. On the surface, we're just looking at government paperwork.
Yeah, just forms and letters.
But underneath, we are going to see how administrative red tape can suddenly threaten a person's livelihood and, frankly, their basic sense of reality. But before we get to Johnny's fight, we really need to establish the baseline.
Right, the catalyst for the whole thing.
Exactly. So I am looking at this initial dismissal letter from the OIPC. It's dated July 2, 2026, from a case review officer named Brandon Smith.
That's the trigger for the whole ordeal.
And it looks as formal as it gets. Official letterhead, P.O. Box 9038 in Victoria, BC, contact numbers, info@oipc.bc.ca, the whole 9 yards.
Very official.
Yeah. And in the letter, this officer cites, quote, sections 49 and 50 of PIPA. He uses those sections to explain why he's declining to investigate Johnny's complaint against an organization called the 127 Society for Housing.
Right.
So before we get into the specific reasons, what actually are sections 49 and 50? Like, does a watchdog really have the power to just say, no, thanks, we're not looking into this?
They do, actually, and it is a fundamental mechanism of administrative law.
Really?
Yeah, think about why an agency like the OIPC exists. They're tasked with overseeing privacy rights for millions of people and thousands of organizations. They manage overwhelming caseloads.
I can only imagine.
So, sections 49 and 50 give the commissioner the statutory discretion to filter out claims. If a complaint is deemed frivolous, or if the issue has already been reasonably resolved between the parties, the agency legally doesn't have to launch a full-scale investigation.
Okay, so it's a filter.
Exactly. They need that pressure valve, otherwise the entire system would just collapse under the weight of minor disputes.
That makes sense in theory, right? You need a filter. But the reason Officer Smith gives for using that filter is what completely baffles me.
Oh, yeah.
He writes that he is declining the investigation because the 127 Society provided a, quote, fair and reasonable response, and that there is no evidence that the organization has not complied with PIPA. I mean, it's like reporting a bank robbery and the police sending you an automated email saying, well, we asked the robbers and they said they didn't do it, so we consider the matter resolved. How can a watchdog declare there is zero evidence just by taking the organization's word for it?
This gets to the very heart of how systemic pressures create bureaucratic blind spots. When a case review officer is staring down a massive backlog, they start relying on procedural shortcuts. If the organization being complained about replies with something that looks formally correct.
Like it has nice letterhead.
Exactly. Maybe they send back a polished letter with professional stationery, citing a few internal policies. The reviewer might just look at the format rather than the actual substance.
Oh, wow.
They see a coherent response, they check the box that says fair and reasonable, and they clear the file off their desk.
So it's like a teacher grading a final exam by only looking to see if the student used the right font and proper margins.
Yeah.
But never actually reading the essays to see if the answers make any sense.
That is a perfect way to visualize it.
Yeah.
And the danger there is profound. When an oversight body confuses a polite, properly formatted response with actual legal compliance, they risk rubber stamping severe violations.
Which is exactly what seems to have happened here. And normally, receiving a formal rejection like that is the end of the line. You see the government seal, you read no evidence, and you just give up.
Most people would.
But the glaring contradictions in this specific letter actually handed Johnny the ammunition he needed to fight back. I'm looking at his response now. He sent it the very next day, July 3, 2026.
He did not waste any time.
No, he didn't. It's a formal reconsideration request sent directly to Commissioner Michael Harvey. Is this just like a fancy way of appealing?
It is much heavier than a standard appeal. A reconsideration request is a formal, legally weighted mechanism. You are essentially forcing the regulator to look in the mirror.
Interesting.
You're telling the agency, you failed to execute your statutory duty, and here's the documented proof. It requires laying out the exact legal or factual errors the officer made.
And Johnny definitely brings the receipts. Let's look at how he breaks this down in ground one of his request. In his original complaint, which he references here, he actually included a memo written by the 127 Society themselves.
Right, the March 24th memo.
Exactly, dated March 24th, 2026. And it plainly states that for a standard annual rent review, residents only need to provide 3 months of bank statements.
Which is a very normal threshold for income-tested or subsidized housing. You need to verify that the tenant still qualifies for the subsidy. 3 months gives you a clear snapshot of their financial reality without being wildly intrusive.
Right. But I'm reading what they actually demanded from Johnny for this exact same routine review. They didn't ask for 3 months. They demanded 12 months of full banking records.
A whole year?
A whole year. And it gets crazier. They demanded the full names and home addresses of third parties, specifically his friends and family who had helped support him.
Yeah, that's just...
And they also demanded a municipal business license and CRA charity registration documents.
So what's fascinating here is how fundamentally this shatters the core pillars of the Personal Information Protection Act. PIPA was designed to balance an organization's legitimate need to collect data for its operations with an individual's fundamental right to privacy.
Right, a balance.
Exactly. And the two biggest pillars of that balance are consent and reasonableness. You simply cannot collect personal information unless a reasonable person would consider it appropriate for the circumstances.
So what does this all mean? If a landlord asking for 3 months of bank statements is a standard background check, asking for your friends' home addresses and CRA charity documents feels like a full-blown interrogation.
It is wildly disproportionate.
Yeah.
Demanding business licenses and a full year of transactions for a routine residential tenancy review completely fails the reasonableness test.
Absolutely.
But the collection of the third-party data, the friends and family, is an even more massive legal line to cross. Those individuals have absolutely no relationship with the 127 Society.
They don't live there.
They never consented to have their personal information collected, stored, or scrutinized by a housing provider.
Johnny couldn't legally give consent on behalf of his friends, even if he wanted to.
Precisely. And this is why Johnny's rebuttal is so devastating to the OIPC's credibility. He points out that case officer Brandon Smith concluded the Housing Society provided a fair and reasonable response, while entirely ignoring this documented difference in treatment.
It's right there in black and white.
How can a regulatory body state there's no arguable issue when the complainant has provided black and white evidence of an organization attempting to illegally harvest third-party data?
I mean, they either didn't read the evidence memo or they read it and just didn't care.
It's one or the other.
And if the OIPC missed that massive overreach on the banking documents and the family addresses, how did they handle the fact that the Housing Society was literally putting words in the watchdog's mouth?
You're talking about the pre-clearance claim, grounds 2 and 3.
Yes. Johnny details this in his letter. During the internal complaint process, the executive director of the 127 Society explicitly wrote to Johnny, claiming, and I quote, OIPC has confirmed we are following PIPA.
That is incredibly dangerous territory for an organization.
Right.
The OIPC does not generally hand out blanket pre-confirmations. They don't audit a housing society and issue a golden ticket saying you are pre-cleared to do whatever you want. They investigate specific complaints.
So it was a false claim of endorsement?
Essentially, yes.
They were weaponizing the OIPC's name to intimidate a tenant into handing over his private data. And when Johnny explicitly flagged this false claim to the OIPC, case officer Smith just ignored it. He called the organization's behavior fair and reasonable without ever addressing the fact that they were lying about having the OIPC's official blessing.
This raises an important question about regulatory integrity. When an oversight body allows its own authority to be used as a blunt instrument to bypass a citizen's privacy rights,
Wow.
and then fails to penalize the organization for doing so, they cross a line. They stop being an impartial watchdog and functionally become complicit in the intimidation.
Okay, but here's where it gets really interesting. Because if you are sitting there listening to this and wondering, how on earth does a government agency miss 12 months of bank statements, third-party addresses, and a false endorsement?
Yeah, how does that happen?
Well, Johnny finds something in the OIPC's own letter that explains exactly how closely they were paying attention.
The date discrepancy.
Yeah.
The time-traveling typo.
Yes. So we established earlier that the OIPC's official decline letter from Brandon Smith is dated July 2, 2026.
Right.
But in the very first paragraph of that same letter, Smith writes, "We received your complaint on July 10th, 2026.
He is officially claiming to have received the complaint 8 days after you wrote the letter declining to investigate it.
It's wild. And just to ground this in our timeline for you listening, based on the date of Johnny's rebuttal, today is July 5, 2026.
Right.
The OIPC is sending out stamped formal rejection letters claiming they processed complaints from 5 days in the future.
It's unbelievable.
Johnny notes in his appeal that he actually submitted his complaint by email way back on June 10th. They didn't just get the day wrong, they got the entire month wrong.
You know, on the surface, you might look at that and think, okay, someone hit the wrong key on a keyboard, it's a typo.
Sure.
But in the context of administrative law, especially when paired with everything else we've discussed, it is a glaring symptom of institutional rot. It's what we call maladministration.
Maladministration? That sounds much heavier than just being bad at your job. What does that actually mean legally?
Maladministration is a failure to carry out statutory duties properly. It isn't just making a mistake. It is about the systemic breakdown of process.
Okay.
If you look at the exhibit posters included in our source stack, this pattern starts to align perfectly with those definitions. Figure 2 illustrates general OIPC administrative complaints, but Figure 3 specifically deals with allegations of maladministration. When an agency is so reliant on automated bureaucracy and rushed reviews that they don't even know what month the complaint was filed, it proves they aren't actually reviewing the file.
Well, yeah, if you don't know when the complaint came in, you definitely didn't read the March 24th evidence memo attached to it.
Exactly. And when you couple that sloppy file handling with ignoring documented noncompliance and failing to check a false claim of your own endorsement, it breaks public trust completely.
Absolutely.
Actually, Figure 1 in the exhibits references a poster regarding an organization's use of threats. That is crucial here. A false claim of regulatory endorsement used to extract data is a form of bureaucratic threat. The OIPC's failure to address it is textbook maladministration.
Which brings us to the most vital part of this entire deep dive, because all of this talk about Sections 49 and 50, PIPA regulations, maladministration, and dates from the future.
We can start to feel a bit clinical.
Yeah, it feels like a debate over paperwork, until you realize why these documents were being demanded in the first place and who they were being demanded from.
The human element is what anchors this entire case.
Right at the end of his July 3 reconsideration request, Johnny Zakharia provides the reality of his situation. He states clearly that he is a partially blind senior receiving disability assistance.
And that completely reframes the power dynamic of everything we've just discussed.
It changes everything. These aren't just abstract privacy violations happening in a vacuum. The demands for 12 months of financial records, the demands for his friends' addresses, the charity documents, they are all directly tied to a rent review.
Right.
The 127 Society isn't just auditing him for fun. They are trying to raise Johnny's rent from a subsidized rate of $340 a month up to a staggering $1,545 per month, effective July 1st, 2026.
That is a more than 400% increase on a senior living on a fixed disability income.
Put yourself in those shoes for a moment. You are visually impaired. You are surviving on a very limited fixed assistance check. Your rent is about to jump by over $1,200 a month, essentially threatening you with imminent homelessness.
It's terrifying.
And you take this fight to the residential tenancy branch to dispute the increase. But while you are fighting for your basic survival, your housing provider hits you with a barrage of demands for your most intimate financial history and your family's personal information.
And then the watchdog fails you.
Right. When you finally manage to ask the government watchdog to step in and protect your rights, they send you a form letter from the future telling you that your landlord's behavior is fair and reasonable.
If we connect this to the bigger picture, this is the most crucial lesson in these sources. When we hear the phrase data privacy, we usually think about hackers stealing passwords or, social media algorithms tracking what we buy.
Sure, cookies and targeted ads.
Right. We think of it as a digital modern annoyance. But in the context of subsidized housing in vulnerable populations, demanding excessive personal information is not about marketing. It is used as a bureaucratic weapon.
Because the point isn't actually to get the data, is it?
Often, no. When an organization demands a mountain of irrelevant, highly sensitive documentation from someone they know is already struggling, the goal is to make the process of fighting back so exhausting, so invasive, and so legally complex that the individual simply gives up.
Wow.
It serves as a barrier. You overwhelm them with red tape so they surrender their fight for affordable housing.
And the regulatory body whose entire mandate is to prevent that exact type of overreach just rubber stamped it because they were trying to clear their desk.
They prioritized the appearance of resolution over the reality of compliance. And when regulators do that, the burden of enforcement falls entirely back onto the citizen.
Which is so backwards.
It is. Johnny, despite being partially blind and facing the loss of his home, had to do the OIPC's job for them. He had to meticulously document the legal discrepancies, cite the evidence of third-party breaches, and file a formal reconsideration request just to force the agency to look at the facts of his case.
I mean, it is incredibly resilient on his part, but it is a deeply broken reality for the system.
Extremely broken.
So let's distill what we've unpacked here today. We started with what looked like a standard everyday government rejection letter from the OIPC, a letter that casually claimed there was no evidence of a privacy breach by a housing society.
And through the lens of Johnny's reconsideration request, we explored how that standard dismissal was actually a masterclass in bureaucratic failure.
Yeah.
It ignored overwhelming documented demands for a tenant's private data, including illegal attempts to harvest third-party information without consent.
Right. We saw how a housing organization falsely claimed the OIPC's endorsement to intimidate a tenant and how the watchdog completely failed to hold them accountable. And ultimately, we saw how one citizen, fighting desperately to keep a roof over his head, exposed the deep administrative cracks in the oversight system itself, right down to the watchdog not even knowing what month they were operating in.
It serves as a stark reminder for anyone listening. Your privacy rights might look ironclad on paper, but they are only as strong as the oversight body actually enforcing them in reality.
That's a great point.
If the mechanisms designed to protect you are choked by caseloads and heavily reliant on automated form letters, you are effectively acting as your own watchdog.
Which leaves us with a final thought to chew on. We've seen how easily human case officers, burdened by massive caseloads, can miss glaring red flags and rubber stamp severe privacy violations.
Yeah.
But think about where administrative law is heading. In the next 5 to 10 years, as government agencies increasingly turn to artificial intelligence and automated systems to process these frivolous complaints, what happens to the Johnnies of the world?
Oh, that's a scary thought.
Right. If a human being can look at a demand for a senior's charity records and call it fair and reasonable, imagine how impenetrable that bureaucratic wall becomes when it's entirely run by an algorithm program to just clear the queue.
It would be impossible to break through.
It makes you wonder, the next time you pull an official letter out of your mailbox, you might not just be checking if the dates are from the future. You might have to wonder if a human being ever even looked at it in the first place.